So we move on to the next session, which is moderated by Dr. Arthur Stadler. This is a much more vast topic. They will present multiple industries. So Arthur, the floor is yours. You can take that mic and invite your panelists.
Super, thank you. Yeah, we have one presentation just adding to the to this panel. Thank you very much for being here. Thank you for the audience, especially after. Please take a seat for the whole panel. Come over. We have 4 specialists. Please come over. I'm very happy and glad to be moderating this panel. As you know, we are talking about licensing the Web3. We're talking especially on MiCA. But first of all, I spare the presentation as a moderator. You can only do mistakes. We have 4 specialists on the panel. We have 1 lady, and we have 3 lawyers and 1 compliance expert. I'm also a lawyer from Austria, and I'm also a specialist on crypto and gambling. So we talk about MiCA regulation, but also other regulation. And to set it a bit in the scene and to look at other regulations, we're going to hear a small presentation from Bogdan, and then we're going to talk a bit of a historical reshape, what happened back in 15 years ago in 2017 in Gibraltar. Funny enough, I'm one of the founding members of Bitcoin Austria. In Austria, we are celebrating since 15 years already Bitcoin Pizza Day. Yeah, 15 years. So we look back 15 years, and that was actually a crucial point in history when the first Bitcoin transaction was with real money goods. And actually that's already the time, at latest, that's the time when the regulator needs to think about, hey, is it something to regulate? Is it something where I look at it and do my laissez-faire, or I do strict regulation? And that's where we are. So we'll put it a bit in a historical frame, but beforehand we'll look at other countries, how they dealt with the regulation in South America, Gibraltar, and many other jurisdictions, how their approach was and how they dealt with this new Bitcoin, cryptocurrency landscape, how to deal with it. Yeah, handing over to you.
Yeah. Thank you, Dr. Rosser. Dear friends, dear colleagues, thank you for inviting. My name is Bogdan, Head of Legal at Sonata Investments, a private capital venture investment fund. So before my colleagues proceed with the detailed discussion of the current trends and changes in the European Union and Baltics crypto regulation, I would like to start our discussion with a brief explanation of the summary of the EU regulation and comparing it with multiple other jurisdictions, comparing it with approach of Australia, Brazil, Argentina, Canada, and so on. Because our time format is a little bit limited, I will try to fit everything within 5-7 minutes, so to ensure that after our discussion everyone will have some understanding of the international crypto legislation. So let's start with a brief discussion of the MiCA. As you all may know, the market in the crypto assets regulation came in force in June 2023, and it finally took effect at the end of the previous year. So it's a comprehensive regulatory framework that introduces 3 types of crypto asset classes, 3 groups of regulated activities, responsibilities for crypto asset issuers, and of course the requirements for the local presence on the European Union market, as the previous speakers were discussing. So it includes having at least 1 EU residential director, the place of effective management within European Union, and the registered address in EU. It also introduced the minimum paid-up capital for the crypto operations depending on each specific types of activities you intend to perform. So starting with 50,000 euros per intermediation and consultancy services, positioning of clients' crypto assets and crypto portfolio management, continuing with 125,000 euros euros for traditional services that are commonly known to all crypto exchanges who operate in EU for some time. The crypto-to-crypto exchange, crypto-to-fiat exchange and custody, or crypto wallet services or so-called VASP WASP, and ending up with 150,000 euros per crypto trading platform. The MiCA also introduced the passportization requirement, so it's a common concept that existed in the European Union payment and financial legislation for a long time, and now it was finally implemented at MiCA. It sets the requirements for EU member states and European Union economical area countries how to provide services EU-wide based on one single authorization. It was also not so late introduced the grandfathering period, the period when EU member states and European Union economical countries can adopt to the MiCA. So according to latest changes in Lithuania, we still have 7 months in order to adopt. So let's in few words discuss the regulatory burden depending on the types of activities. There are 2 main types of activities except utility tokens. So for the asset reference tokens, whose value is linked to the real world assets, there are requirements of having at least 350,000 euros or 2% of the total asset reserves. This approach is very similar to what we have to in the electronic money institution regulations. The requirements are very similar. However, according to the practice of UK and other jurisdictions, in order to obtain the full EMI license, it's highly recommended to have at least 1 million euros before submitting the application. So how it will be regulated in terms of asset reference tokens, we'll see in the nearest future. And I would like to end with Europe on the e-money tokens. So the MiCA introduced so-called per value standard, or 1 per 1, which means that in order to issue so-called stable coins, you need to have the same reserve of currencies issued by the central bank of each specific state for each token that you are going to issue. So because of this requirement set in Article 49 of MiCA, the Tether USDT unfortunately or fortunately doesn't meet with this criteria, which technically means that it's not the e-money token as per MiCA. So let's proceed with other jurisdiction. We've selected Argentina for a very nice reason, because it's a very new regulation that will take effect, is expected that it will be finally take effect at September 2025. It's very similar to what we have in MiCA. So it regulates up to 5 types of activities, starting with the crypto-to-crypto exchange, crypto-to-fiat exchange, custody services, crypto transfer services, and the platforms for issuing crypto. So when it comes to the present requirements, they're at least a little bit less strict than what we have in EU. You are not required to have the local office or local employees. However, you're required to have at least 1 residential director, so at least 1 director residing in Argentina who will act as a compliance officer. If to compare the minimum paid up capital or minimum net worth, as you may see, the requirements are very similar, starting with 35,000 US dollars per ICO platforms or the platforms for issuing tokens, and ending up with 150,000 US dollars per traditional crypto exchange services such as crypto-to-crypto exchange, custody, and so on. So let's proceed and briefly discuss Australia. So Australia used to be quite crypto-friendly jurisdiction. However, its current regulatory framework is going to be changed within the nearest time. Yes, unfortunately, it's a little bit cut, but I will tell you what's exactly located about. The services that are allowed to provide in Australia, they are very similar, much less services than what we have according to the MiCA in EU. It includes solely the crypto-to-crypto exchange, crypto-to-fiat exchange, and 2 indirectly permitted activities such as operating as the crypto ATM and crypto transfers if they're related to the exchange. There are currently no minimum paid up capital requirements and no requirements to the local substance. However, the Treasury of Australia and the Reserve Bank of Australia introduced that till the end of this year they will publish the new regulatory framework that will include the regulatory framework for stable coins, tokenization, real-world assets, and it will increase the standards and requirements for the digital currency exchange providers, which is an equivalent for CASPs or WASPs in EU. So technically, it's, I will not say that this is easier than in EU, and it's expected that it would be adopted according to the best practices of MiCA implementation. So for some reason, yes, we cannot see all the entire presentation, but that's not a problem. So let's proceed and discuss the Canada. What do we know about Canada? So basically, it is the same as Australia, but without snakes. However, their crypto regulation is slightly different. So when in Australia there is a separate regulation for crypto activities, in Canada there is no such separation right now. So the payment regulation and crypto regulation are running under the same regime, so-called money service business registration. So it's a common registration that allows you to provide both fintech and crypto activities. It includes such activities as provision of payment services, foreign exchange dealing in virtual currencies, which is very important, crypto crowdfunding services, remittance and transferring of the funds. So in general, it's currently very similar, very simple regimes that doesn't require you to have the local presence or local office. However, according to the latest changes, if you intend to provide the payment services and especially to hold the funds of your clients, you're required to have a separate registration within the Central Bank of Canada. And it's highly expected that within the nearest times, the Canadian crypto regulation will change dramatically, will introduce the minimum paid-up capital requirements, that substance, and will be more likely than MiCA. And the third jurisdiction is Argentina. It's probably one of the toughest crypto regulations. It was also selected for a good reason, because it's a common concept that MiCA regulation is quite strict approach. However, Brazil, that's what exactly is a strict approach. According to the latest changes in Brazil legislation, when its current regulatory approach passed the public consultations at the beginning of this year and is expected to be implemented in the late 2025, the Brazilian crypto regulatory approach has up to 7 types of different activities that include crypto to crypto exchange, crypto to fiat exchange, custody services, margin or staking services, and operating as a brokerage platform for crypto assets. So when it comes to the substance requirements or the local presence on the Brazilian market, you're required to have at least 3 administrators, at least one of which must be appointed as the compliance officer. When it comes to the minimum paid-up capital requirements, they're 3 times higher than what we have in MiCA right now. So for example, for traditional crypto exchange services, which by MiCA equivalent would be the second class with the paid-up capital requirements of 125,000 euros. In Brazil, in order to operate as the crypto exchange under this regime, you would be required to have at least 175,000 US dollars in equivalent in terms of the minimum paid-up capital for exchange operations. For custody services, it's even higher, 350,000 US dollars. And for operation as the brokerage platform, it starts with 525,000 euros, which is 3 times higher than what we have in MiCA. Yep, so that's it, dear colleagues. On this point, I would like to thank you for attention, indicate that MiCA is definitely the innovative and quite balanced approach that we are having right now. Most of the countries are adopting their crypto regulation according to the best practices of MiCA. Thank you very much for attention, and I would like to transfer the words to my colleagues.
Well, you're still on the panel, so we're still discussing things. No, why do we flood you with so much information? And Genius, thank you for this overview. And in just very few minutes, so many jurisdictions. Why do we do that? Because we are discussing also the approach, what different regulators take, or what we've seen also in the past. And I'm looking to you, Romanos. You have a broad experience and you're an expert on this panel. What happened in the past, looking back at Gibraltar 2017, what did other regulators take as a different approach? Or what can we take from the past, taking you over for the present or for the future? What is good and what is bad with the MiCA regulation?
Yeah, thank you for the introduction, and thank you, Bogdan, for the very highly loaded presentation. And as we see from the file name, it was shortened version of the presentation. So really appreciate your preparation. Different regulators in different jurisdictions, they always evolving, and it's not about choosing the jurisdiction which is stable. It never be stable, So the business-wise, it's more important, what actually the regulators adopt and what are their stance towards the the businesses they regulate. And this comes with a bit of a history. At Damex, which is just a crypto exchange, but an early beginner, from 2017, we have started, in Gibraltar, when it was the first opportunity to be regulated at all across the globe, let's say. And in that time, it was like the hyping about the Bitcoin. It was no regulation. It was very immature industry, high growth, and a lot of uncertainties. And what Gibraltar regulators they did, they just took an approach of a MiFID framework, basically, in the essence, very strict and client-oriented, and put on top the whole, layer of understanding what the blockchain is. So this was the first, let's say, attempt to develop some sort of the uniform framework for regulating crypto businesses. This was called DLT license, and Damex was one of the first 7, crypto businesses in the first cohort being licensed. And at that time, it was a new thing, and what is most importantly, it was not a prohibitive or restrictive measure, from the Gibraltar authorities, but rather they collaborated. And they tried to understand the business, and since ever then, Damex and alikes, they operate in Gibraltar from the compliance first perspective. But having a healthy dialogue with the regulator, it means, really consultations, audits, reporting, everything which we see now in many jurisdictions, it was started there. And it was always a balance of this, between the business logic and oversight, needs for oversight. So that's the historical perspective.
Isn't there, as always, isn't there a risk, like the typical Delaware effect? Yeah, isn't there a risk that you have hop-on, hop-off operators or companies choosing the easiest way how to get the license? And what do you think of it? I mean, is it still the Delaware effect, or do you think the regulation or the regulatory bodies have learned enough to really compete? What do you think about it?
Yeah, so if you take a short time frame, like a couple of years, and a newly established, gambling crypto business, high-risk business, they, lure into this, jurisdictional shopping, and in the short time, it looks like everything is changing. We are going to surf that wave. But if you take a 5 or 7 years perspective, if you're establishing a longer business perspective with the bigger investment and a really long-term strategy, then you find out that basically there is a waves of regulatory changes which are like going almost uniform way. This is what Bogdan just demonstrated as that we have, let's say, many jurisdictions just like we have a trend-setting MiCA effort from EU, and many jurisdictions now follow into that. So in a couple of years time it will synchronize in a new balance state. So the first balance state was 2017-2018 when the first regulations kicked in. Then it will repeat, So this jurisdictional shopping and the licensing, hop on, hop off, it's really stretching the compliance resources of the company. And we also operate not only in Gibraltar. We have a Lithuanian branch, we have the Maltese entity, we have Isle of Man, Seychelles, and Damex is always, like filling ourselves fragmented, overstretched through many jurisdictions, and we, really welcome a more uniform approach, across the globe.
Yeah, that would have been my question. Do you overstretch it? I mean, do you recommend for anybody else in the room or for any company what you're advising, that you do several jurisdictions, or just you go for one, like Malta, like Gibraltar you mentioned, Isle of Man? Isn't it an overstretching, or is it worth doing several regulations?
So yeah, of course, one anchor jurisdiction should be, and this is the Gibraltar for us. But for MiCA, we need a European expansion. That's why Malta and Lithuania. And as it was told, the regulatory uncertainty brings you some, tactical moves, But ultimately, you need to have to choose the jurisdiction the best for you. And this comes to the point. What is the size of the business? What is your risk appetite? What is your actual, stance in compliance? And then it comes about not choosing the country, if you like, we saw nice flags, and temperatures, and different, jurisdictions, but you need to choose whether it should be, the large country, which is maybe slower and more, overwhelmed with other, issues, or you can choose the smaller jurisdictions like Estonia, like Lithuania, Latvia, Malta, which are more keen to have a dialogue and not to, to kill the business, with regulation.
Yeah, thank you, Roman. That is rather from an approach from a compliance officer, but jumping over to a legal advisor, to a lawyer, Anna, there is a block of you cannot choose any jurisdiction, this hopping on, off, what you've just heard, there's a block. I mean, especially if you're familiar with legal international private law, you need a special tangible good or something, a connecting point to a jurisdiction. That's one of the burdens. And the other burden is, what we just mentioned, is that MiCA is also subject to high critical points. It's not a real harmonization, what was the goal, but we've seen that special or different regulatory bodies interpret and define the norms in a different way. What's your point on that?
Yes, hello dear audience, nice to see you all and nice to see some colleagues as well. My name is Anna Ago, I'm managing partner and co-founder at Lex Law Office. We're a law firm based in Tallinn, Estonia and Vilnius, Lithuania, advising mainly fintech, crypto, iGaming and technology companies with the legal and compliance matters. We started to work with crypto clients since 2017. Estonia was the first country who started to introduce a regulatory regime for the virtual asset service providers. We have the national law since 2017. And it was a challenging time because the requirements for getting the license were not very strict. So it attracted a lot of different companies around the world to Estonia to just get the license with the minimal requirements, let's say like this. But our parliament reflected very fast on this, so we changed the regulation already 3 times in terms of the crypto national regulation, and until now we had the regime which is quite similar to the MiCA. And now with the MiCA we have, let's say, new stage, new fundamental requirements within the European Union. The big aim of this regulation is to have harmonization within the European Union. But what we see in practice is that, yes, we do have different interpretation by the national authorities in terms of the several provisions of the MiCA. And if we are coming back to this amazing question with the jurisdictional shopping, I had a panel discussion with the head of FSA in Estonia, and he said very well, it's always will be there. We cannot do nothing with this. But I would like to point that actually authorities, FSAs, FIUs, national banks who are issuing the MiCA license, they're having a very good cooperation and they're sharing the information. So if you do have a plan to go for the 3-4 jurisdiction, This is most likely that your regulator will get this information, and while you will have the pre-assessment, they will address those questions.
But that happened in the last 3 years or
Yes,
2 years, no?
yes, and it's the same as for another financial institution. So if you apply for the licensing for the e-money institution and you do have the presence, active presence in other jurisdiction, you will receive the questions for this. And basically there is like a common legal term that majority interest within the country. So you need to prove to the regulator that you do have an interest in this particular country, and that's why you should be registered and regulated there.
So that's where the lawyers jump in and create creative arguments why in Estonia and why not in Austria, for example.
Yes, yes, yes. So it's very, very important to structure it correctly, it presented correctly to the regulator to get approved, actually. And the good tool for this, it's not available in all jurisdictions, but within the MiCA, some of the national authorities, they are introducing the pre-assessment tool, which is basically an opportunity to introduce your project before you apply for the licensing process officially, and it's giving a chance for the companies to get a feedback on the structure, governance, business model, operational activities, cybersecurity aspects, IT system they use, partners they use, to get, let's say, the feel if we can be accepted by the regulator or we need to make some changes in our business model and views. In terms of the MiCA, I think that if we are talking about the challenges, we do have like a kind of 6 months of MiCA until now, and we can confirm that we see the tendency that jurisdictions who had the shorter period of the grandfathering transition period, they are now extending this period, and they are not really ready to review the applications within 5-6 months, because it's really tough. And as some of my colleagues, you I think already mentioned, if we are looking on the specific requirements related to the authorization, they are very similar to the e-money institution, and if we are talking about the real approach of the regulators, even more tough. Because we are talking about the crypto as a high-risk industry, and for the regulators it's it's sometimes challenging as well, and they are asking a lot of questions, so you need to be prepared very well. And for the market participants, I think this is one of the main aspects that they need to pay an attention. They need to prepare in advance, be aware of the statements of the particular national authorities, and start the preparation and adoption to MiCA in advance.
That was the point, statements of authorities. I mean, Boris, we have, sorry, Ivan, sorry, names. Ivan, we have heard, sorry, Mike, we have heard that we need the statements and we need certain definitions, how the different regulatory bodies interpret MiCA. And even what do you think, mentioning Czech Republic or Poland, there's no indication at all, or what we've heard, and interpretations and definitions are coming late. What do you think? That's one of the massive critics of MiCA, that the real harmonization is not yet in place.
Yeah, thank you. Firstly, I would like to slightly represent myself. So we work as B2B lawyers, we work with different jurisdictions, as Bogdan mentioned a lot, so we also working with them. And if you're talking about MiCA, we have a great presence in Poland and Czech Republic, with what we are dealing with. So if we are talking about Poland, and it is a total mess, I would say, because the bill still not passed, and we just have some rumors what will be a transitional period. According to the new bill, it would be 3 months, and the rules are pretty strict, and they comply with MiCA regulations, but again, it's a total mess and total non-prediction. A lot of businesses, what we supported, they just decided to stop going with Poland and decided to move to another jurisdiction where the regulator clarity is more, and you just know what you need to wait and what you anticipate from the regulator. That's very important point is the clarity from the regulator in how to attract some businesses to your country. If you're talking about Czech Republic, the things are better. They do not have a specific bill, but they refer to general MiCA regulation. But generally, the process will be ended on 31 July. So yeah, we are now preparing an application, and the application will be started soon. So in Czech Republic is better. I like also regulation in Malta and Lithuania as a top jurisdiction as for me for regulatory clarity, because in Lithuania it is a bill where you can just check the procedure and move forward, and you have quite clear requirements. And Malta is a very clear procedure because they were quite well prepared for MiCA regulation. That's why, if you want some clarity, yeah, I would say you need to go to Malta and Lithuania. However, a lot of businesses were registered before in Poland and Czech Republic and have entities, and it was so easy because you just register a company, you get a crypto authorization, that's all. So a lot of businesses wish to move forward with Czech Republic and Poland, and the backup also it's pretty sure.
But what do you recommend for companies already set up in Poland or Czech Republic? Should they jump over to Lithuania, or should they continue, wait for the regulator? What's your suggestion?
It sounds very easy. Just let's jump to another jurisdiction. But if you jump to another jurisdiction, you need to create substance. You need to hire employees. You need to have an entity to be eligible for a transition period. So you need something to take money or buy this entity. It's also not an easy process to find the proper entity to buy. And of course, creating a substance to know new laws and to comply with it. If your software comply, if your if you comply with all requirements, it's very hard. It was difficult to just change the jurisdiction. So for our clients, we advise to stay in Czech Republic and Poland and move with that entity, and as backup, if they have enough money to do a deal with it, to diversify risks and make other entities. It is good if some businesses can allow themselves to have some 2 MiCA licenses for 2 entities, but a lot of businesses just don't have enough money to do it because it's very expensive stuff, and they jump to non-EU jurisdictions. That's also the way how to deal with it.
You mentioned the multi-license approach. Yeah? Anna or Romanos, what do you think? What's your take on that? Would you recommend for companies, maybe bigger companies, to have similar or multiple licenses throughout Europe, so that you can choose when the regulator is not that fit and quick, that you go rather for a Maltese one, then you have a parallel one in Lithuania. What's your take on it?
Yes, thank you so much. I will answer that it really depends. It really depends on the company needs. Of course, if we are talking about the company-wise, business-wise, companies are always looking for the solutions which are the most suitable for their business models. And it might work in some cases. For example, we do have a client who is planning from the scratch to apply for the 2 different licenses in 2 different European jurisdictions, and they are dividing the business model to 2 entities. So a particular entity, let's say in Lithuania, will provide only exchange services, and they go for the license with the Central Bank of Lithuania, and then another entity, for example, in Czech Republic, who will provide the custody and transfer of the virtual asset services. And the idea behind this is that actually there is strict separation between the business lines, and they do not want to accumulate all the risk in one legal entity. And in that case, it can be reasonable, but for the regulator, once again, you need to prove, you need to be very transparent in your communication, and you need to explain why you need actually to be regulated in 2 different jurisdictions within the European Union if MiCA allows the full passporting rights once you are registered with a particular member state. And another aspect, I think that we touched this a little bit in the beginning of the panel discussion, is actually this is not a good taste to like do this jurisdictional topping and test here and test there, have the communication with one regulator, prepare all the documents there, and on the final stage say, okay, great, you are not fast enough, I will go to Malta because I got confirmation yesterday there. It's not a good like taste of the business, let's say, operational activities and communication with the regulator. If you do have a long-term strategy and you would like to long last, you need to think from the scratch, invest in the road mapping, in the structure planning, in the discussion with your particular regulator to understand in general, not about only the regulator's approach. You need to understand what are the tax regimes in the particular country, court regime, what about the business environment, can I find the labor, like personnel in this particular country, what about the access to the investment, what about the reputation of the country, what about the banking access. All of these aspects are extremely important, and especially if we touch the topic with the Czech Republic, we do also have the clients from there. And interesting approach by countries. Some countries say that until the end of the grandfathering period, you need to get the license, and that's all. For example, in Estonia, we have 18 months. So until the final deadline, 1st of July 2026, you need to get the license, and that's all. It doesn't matter when you submit your license, you need to be ready by that date. And for example, Czech Republic is absolutely another approach. So they do have first deadline, which is 1st July 2025, until which you need to submit your application, and then you need to get your answer until the July 2026. So they leave 1 year basically for the review period of the license, which is a good let's say sign that it will be very intensive, right? And for example, yeah, in other jurisdictions they do have also the let's say grandfathering provision, which says that you need to submit the application until the specific deadline. So yeah, you always need to have a look on the broader let's say picture, rather deciding where it's easier to get or where the regulator is paying less attention. It's not the smart strategy.
Talking about broader, and we talked about the overstretching. I mean, this is only possible if you're a medium-sized or big company. For a small-sized company, it's almost impossible to multiple license approach, no? What do you think, Romanos?
Thank you. It's really a tough task, and operationally in DAMEX we have the headquarters, main compliance group, which is roughly 12 people, and we have multiple jurisdictions, on the let's say intercompany agreement setup. So in different jurisdictions we might have 3 to 5 compliance people on the ground. Yes, being the mid-sized company, it's always a challenge, and I would like to raise another perspective of that look at the jurisdiction actually to regulator, So they also understand that, some bandwagon goes, to Estonia, then everybody runs to Lithuania, then, it's tightening here, everybody runs to Poland. So this way, regulators themselves cannot predict their resources. They also investing in the people, growing teams, and it's much harder to do it in the public sector. So this comes to my last advice. Let's say, if you are still undecisive, and looking at these lengthy presentations of many jurisdictions, many flags, and all over the globe, look not only on the formal requirements which are written, but also see what is the attitude of that country's regulator, what is their stand. They are staffing up, beefing up their resources, doing trainings, doing a lot of events, providing consultation papers and communication, or they're completely silent. They just, brought a big framework online, just read it and apply. That's the bad sign, because you might find yourself in a situation when you come to this jurisdiction, you have a best lawyers, from our panel, and they will set you all the documentation and you hire people, but then nobody is listening to you over the fence, there is nobody there, they are just understaffed and they cannot just respond on time, and you will find yourself in courts, and say, telling the bad stories in the bar, how bad experience it was.
Bogdan, what's your take?
Yes, thank you. Thank you for providing the words, dear colleagues, because unfortunately had to shorten the presentation. That's a very wide question regarding the multiple jurisdictions, and selecting the main point of the presentation intended to be that right now all the EU member states are changing their requirements in terms of the reverse solicitation, same as international. It's very narrowing. For example, few words, Argentina now requires, if you want to operate based on any foreign license, registration or authorization there, if you have at least 20% of customers in Argentina have AR domain or use the Spanish language, you automatically fall under the licensing requirements despite the fact where you have the license. The same situation we have in EU. The concept with two license may sound interesting, however, if to try to make some analogies with the payment or financial legislation, there is of course a passporting regime that allows you technically to provide the services across entire European Union. However, let's discuss how it's technically provided, what's the mechanics of the passporting according to the MiCA. There are few ways how you can provide the services based on one jurisdiction in entire European Union. It can be done either by establishing representative office or through the right to conduct your services across European Union. However, you are always required to notify the local regulator, the regulator of the country where you intend to finally distribute the services. And because you need to inform each specific regulator, you should as well select the first country where you obtain the license, because if the regulatory framework would be the easiest among EU, let's say MiCA implementation without any extra requirements, it can on practice it can become that some jurisdictions will approve some other jurisdictions faster who have the stricter requirements, and if some jurisdictions will as it was with Poland, when one time in Poland it had almost 50% of all crypto authorization across entire European Union. The requirements were to have the passport and utility bill. It was everything that you need to have for obtaining the authorization. And in case with other countries, I guess that the two licensing concept may work if you have a specific purpose for this under your business model. If you do not have any intention to divide your business, to divide the regulatory risks and so on, so basically it would be better to select first of all the jurisdiction where you intend to have the maximum clients. Subsequently, the jurisdictions that you deem would appropriately be allowed to passport service according to other jurisdictions, because passporting is always about permission of the country where you intend finally to provide the services. That's not about the country where you obtain this authorization. So,
Ivan, what's your take? Sorry.
Yeah, and I would like to add about the principle of reverse solicitation, because it's a very good principle for startups, because that's what startups use, and the principle what they should say thank you for this, because for now, if you do not have direct marketing at some region, you can onboard some of the clients, and that's a good reasons why a lot of companies they still create companies in offshore jurisdictions and some non-EU countries also, Because if we are talking about MiCA prosperity, it's very good. It's strict regulation. It gives a lot of prosperity, transparency. It gives a lot of control, and at the end, the market will probably prosper because good banking system. Because it gives access to marketing. Will be no problems with Google, with Facebook, with other marketing methods. So for businesses, it's like stimulating the businesses to apply for a MiCA to allow them to use some advantages of this MiCA license. As a previous speaker also told, that some regulator, for example, from gambling companies even, they will allow to do crypto processing only for MiCA licensed companies. That's also a good point. That also stimulates some businesses to take these licenses. And for other jurisdictions, will be not easy to deal with market. I think in 10 years, as Roman said, because it will be much harder for startups to enter the market, and it will be very hard to compete because a lot of advantages of local and as Brazil, as Argentina, as EU markets, if you have a local license, it will give you a lot of advantages.
I know, that's your point, startups. I mean, the compliance burden is very high. Is it feasible for startups?
You know, I was in Davos and there was one amazing presentation, and there was a business research on the CASPs. What are the costs according to MiCA on the compliance only? And guess what? What is the number? It's at least $500,000 per year. So we are talking about the heavily regulated market. The MiCA is step number one. This is the layer one. We will see on the top of this each year, maybe even faster, we will have additional layers. We do not have the clarity with the NFTs, we do not have the clarity with the DeFi, and several let's say Web3 models which will be regulated as well, no doubt about this. The question is when. And if we are talking about the startups or small innovative companies, let's be transparent, it will be very hard to enter the European market for them. This is the reality. But I think that solution that they might use, first of all, they need to find the suitable partners, RegTech companies maybe, who are providing the solutions for them, good outsourcing compliance providers. For example, I'm also a part of the MiCA expert project, and we created the legal tools for the CASP to comply with the MiCA. For example, we created the checklist, which helped to evaluate how ready you are, and you can get the quick answers, where are the gaps, what should be reviewed. And also we created the templates for the policies and procedures that might be customized according to specific jurisdiction and specific business model. So some kinds of solutions like this, it can be used. In addition to this, please be active in the particular markets, participate different associations, smaller events where shareholders, compliance officers are sharing their experience, how the things are going with the regulator, how transparent this market is. It's also helping to cut the cost, let's say, and avoid the possible mistakes or risks. And of course, for the startups, it's important to think from the scratch about the business continuity. And basically, you cannot get approved by the, let's say, regulator when you cannot prove that you are financially stable. You need to submit the financial forecast, business continuity. You need to prove that all the processes within the company can be successful and can last for long. And this is a requirements coming from the MiCA. So yes, it's complicated and challenging, but it is not impossible. And of course, it is always a question of the good personnel in the particular company, good advisors, good partners. You need to be very selective, and you need to think about the business model as well, because to be the transparent crypto market market. It's a very heavily concurring market, so they do have a lot of competitors, and it's hard to enter even from this perspective.
Looking at the time, that sounded already like closing remarks. What's your closing remarks, Romanos?
Yeah, I just want to refrain on this idea of looking into jurisdiction in a complex way. You know, whether the talents are available, whether RegTech, local providers are available, and many other, let's say, which makes a healthy ecosystem. And Lithuania is one of that countries. You know, we really have a strong RegTech, community here. We have a lot of compliance, and specialized expert teams and software providers. Also, cybersecurity infrastructure in Lithuania is at the forefront of this cyber wars. We are really strong here in DORA compliance and making your fintech infrastructure resilient. So I welcome everyone, to deep dive, into Lithuanian, opportunities that we bring here. And a closing remark about, all these perspectives on regulation, like we spoke about regulators themselves, legal perspective, then the compliance team perspective, companies themselves. Just let's not forget the investors' perspective, So for investors, it just needs, that they will need to invest more, and that's how the startups get more, money to actually comply and build their compliance, competences. If you would like to enter this highly regulated markets and get your premium, invest more. So that's the latest remark. Thank you.
Ivan, your closing remarks, especially the challenges also from Poland and Czech Republic. What remains from MiCA? I mean, is it worth staying like it is, or shall we push for amendments?
Yeah, if we are talking about MiCA, I would say it is always a matter of purpose of business, and if you need this MiCA license, you need this MiCA license if you only want to work in your market. It is not necessary if you want to work, for example, outside of European Union. You should look at other countries. That's a very important to remember. And it's also a matter of the size of your business. So if you are small, you want to try, you need to have a just low-cost solution just to test your business, if it's okay, if your business model is right, if you can do it. And it's a very good point was also mentioned. It's a very important matter of partnerships. Because, for example, if you are talking about a new trends and, for example, UK regulation, UK regulation was quite strict, and it was introduced long ago before MiCA. So there is a fin promotion regulation. So it's when you can operate under the umbrella of some other licensed company. That's a very good point, because I think the market is going on this, because only big size companies will allow them to get MiCA license. The market, it will be very difficult to enter the market after 5 years. So yeah, we need to know the purpose. Why do you need license, and find the way how to make your cost effective. That's very important.
Bogdan, only for big companies?
Dear colleagues, also wanted to add a little bit and agree with my colleagues. So as the lawyer who is currently working as the head of legal at investment fund, for all small and medium-sized businesses, in terms of MiCA, I will highly recommend to search some reputable and adequate investor, because each time when some projects come to our fund and I personally conduct their due diligence process, when I see that the investment amount is much higher, but the project has the plan to obtain the license in the reputable jurisdiction, the fund of course understands that would be it would be the slower return of investment. It would be lower. It would be higher investments, but at the same time, For all the startups, I will highly recommend to consider the adequate licensing strategy, not only to try using some offshore schemes or something like this to risking the regulation, because in general, since the international nature of crypto, you never know where would be your final users. So if you want to obtain the MiCA authorization, operate on absolutely wide field, then just try to consider maybe obtaining some investments for this, because each specific time, as the lawyer who conducts due diligence of startups before issuing them investments, it's extremely important for me to see whether they have an adequate strategy for being legal compliant. And even if the investment amount is higher for fund, we can be sure that our funds are safe, the projects are adequate, and they plan to operate for a very long distance of time, which is much better than to reap the rewards within 2 years and to fall under the legal consequences that may be absolutely unmanaged. So that's my last word here, dear
Thank
colleagues.
you. So you have still your last words, but I'm asking if there are questions in the room. Because I have another question which is on the Baltics, the challenges, so that might be a nice question. Anybody in the room? We're a bit out over the time, but I leave you. I have one question. What are still the challenges for the Baltics? You see that every day. I mean, you're advising under Estonian law, but also Lithuanian laws. What do you think of the approach the Baltics are currently taking?
Yes, I think it's not only about the Baltics, it's in general the challenges that gas projects are facing right now in terms of the adoption of the MiCA, and I would like to point out maybe three main aspects. First of all, this is still unclarity and different interpretation by the national authorities. Secondly, not clear understanding about the importance of the cybersecurity and digital resilience in terms of the DORA especially. And then the third is, yes, the topic that my colleague also touched, the financial stability and business continuity. Sometimes we see also when we are advising the clients misunderstanding about the real costs that they will be facing within the next 3-5 years, and this brings a lot of unclarity in terms of the business model and products, and creates the possible risk related to the approved by the regulators as well. But my final remark will be like make smart decision, choose your partners well. Invest in your employees, and have a long strategy in terms of the compliance and legal. Yeah.
So thank you very much. If there is no more question, yeah, thank you for the panel. Thank you for the experts. And thank you for your time.